In global trade, deals worth millions can be sealed with a single contract. But when things go wrong, the fight over how much money should change hands can be just as big as the deal itself. In 2015, Bunge SA versus Nidera BV asked the UK Supreme Court to answer a deceptively simple question. When a contract is wrongfully terminated, how do you decide the amount of damages owed? Background story: Bunge SA, a Swiss grain trading company, and Nidera BV, a Dutch commodities trader, entered into a contract for the sale of 25,000 metric tons of Russian milling wheat. The shipment was to take place between the 23rd and the 30th of August 2010, FOB free on board Novorossiysk, Russia. The contract incorporated the GAFTA Grain and Feed Trade Association standard terms, which included an arbitration clause. On the 5th of August 2010, Russia announced a ban on wheat exports starting the 15th of August 2010 due to drought and a poor harvest. 2 days later, Bunge informed Nidera that it was cancelling the contract. But here's the twist: the ban was set to begin before the shipment window, meaning the delivery would have been impossible. Nidera, however, claimed Bunge's cancellation was premature and constituted a repudiatory breach. A breach so serious it entitled them to terminate and claim damages. Issue: when a seller wrongfully repudiates a contract before performance is due, but later events show that performance would have been impossible anyway, how should damages be assessed? Rule: under English contract law, damages aim to place the injured party in the position they would have been in had the contract been performed, not to punish the breaching party. The Sale of Goods Act 1979 and the principles in the Golden Victory 2007 allow courts to consider events after the breach, if they are relevant to the actual loss suffered. Application: Nidera argued Bunge's early cancellation was a repudiatory breach. Damages should be calculated based on the market price difference at the time of breach. Bunge argued, even if the cancellation was premature, the Russian export ban meant the contract could never have been performed. Damages should reflect zero loss, since performance was impossible regardless. The GAFTA tribunal initially sided with Nidera, awarding around $3 million in damages. But on appeal, the case reached the UK Supreme Court. The Supreme Court, led by Lord Sumption, ruled in Bunge's favour. Yes, Bunge had wrongfully repudiated the contract. However, damages must reflect the actual loss, and since the export ban would have prevented shipment, Nidera suffered no real loss. Therefore, only nominal damages were awarded. Conclusion: Bunge SA versus Nidera BV 2015 confirmed that when assessing damages for contract breach, courts can take into account supervening events that would have affected performance. The ruling reinforced the principle that damages are compensatory, not punitive. In the world of high-stakes trade, timing is everything, but so is fairness. This case reminded everyone that even when a breach is proven, the payout depends on what was truly lost, not on what might have been. If you found this breakdown helpful, hit like, subscribe, and check out our other contract law case studies.